Hi guys, this is Darren again for Partial Property. Welcome all of you. Today I have Ted with me. I'm so happy to have him here. Okay, I just wanted to just check in with all of you whether you're able to see me clearly and able to just give a thumbs up or a hello down there where you're able to see us and hear us, right? Because it's the first time I'm using this platform, which is Zoom, right? Last week I used another platform, so I'm not so sure whether it is working correctly, right? If you guys are in, please just comment at the bottom so I'm able to see it here to know that everything is actually working well. So guys, so this is Ted Koh. I've met him many years back when I was a junior agent at a time. Okay, all of us has aged gracefully together, all right? So, and he has been the go-to person also for the longest time. I always giving him a call because he was working for various legal firms throughout the past 15 years. So any things I had pertaining to my cases when I was a junior agent all the way to now where there's more complexities and questions that I had, right? So I'll just give him a call and he just give me advice directly, either to change a particular clause in a tenancy agreement to better advise my customer, or to remove some things to better advise another group of customers. Okay, so well, here you are. Thank you very much, Ted. Would you like to just share with everyone what this is about yourself?
Hi, good evening, everyone. I'm Ted here. So I'm from a law firm, Crossborders LLC. So my role in the law firm is to manage the practice. Right? So what I do on a daily basis is I manage the practice as well as attend to the client. My main area is actually in real estate. Right, so that's why Darren has arranged for me to be here tonight, right, to answer all your queries on real estate matters, especially during this COVID-19 period.
Yes. All right. So guys, if you've just joined us, please key in any questions that you have. Right, we just be carry on shooting whatever that we need to see in terms of to discuss in terms of some questions that I've already collected since last week when I sent out the emails and messages. Right. So, but if you have any other queries that you have presently, either as a landlord or as a tenant or as a buyer or seller going through some complex situation that maybe your salesperson is unable to assist you at this point in time, you just drop us a comment inside so we're able to see it, and then Ted can actually address it. All right. So anyway, just to kick off, there are some questions that actually has surfaced, and this is regards to HDB and private properties. All right. So one of the questions is that it's a completion date. So there's a classic case that one of them is facing is that they actually have a completion for the HDB scheduled sometime in the 3rd of June. All right. So this is happening on the 3rd of June, the completion, and right now the sellers are kind of stuck because they have to the COVID-19 situation only finishes 1st of June, and after discussion they tried going online to look for a place to move out, but unfortunately they cannot do that, right? And the buyers is insistent for them to move out on the 3rd of June. Okay, can you just maybe share with the viewers now what is the possible remedies or action taken that the buyer or the seller could take for this particular case?
Okay, so I guess there are a few parts to this question. The first question would be that there is a pending completion that is scheduled to be happening on the 3rd of June. All right. So because of the COVID-19 situation, all right, currently for HDB, all right, cases that have already been scheduled for completion, right, the completions will still happen. So in the example that Darren had given, that would be on the 3rd of June. Now, the question now is that the seller, all right, is saying that he does not want to complete on the 3rd of June. Am I right, Darren?
He's asking for help, and he's asking whether can we delay it by another 2 or 3 weeks so that he has at least had the time to look for a place, discuss with the landlord, clean out the place, and then move, you see?
Okay, yeah. So this is this scenario has been quite a common scenario these days. I would put common scenario these days where because of COVID-19, all right, because of the circuit breaker, a lot of sellers are not able to arrange for their next accommodation. So they're going back to the buyers of their property to say, hey, can I reschedule? Can I delay the handover? Can we move out later and such? Now, based on the relief measures that's been announced this far, nothing has been announced for residential real estate matters, right? So be it whether it's a HDB sale and purchase or a private property sale and purchase, the scheduled completion dates are still due to happen. Now, usually when we have a completion date, right, when there's no circuit breaker, right, on the completion date itself is where the seller has to vacate the property and the buyers will get the keys and access to the property, right? A lot of sellers these days are asking buyers to give them an extension of time to stay and such, right? And a lot of buyers have been asking us, are we obliged to give? Do we have to give, right? The answer is actually no. All right. So as a buyer, the buyer is not obliged because contractually, right, the completion date is in the example Darren given is 3rd of June. So contractually, the seller, right, has to vacate the premises for the completion on the 3rd of June. Right. So question would be, what if the seller claims that they can't move out because of the circuit breaker? Now, for moving services, they are still available. So there's no reason why the seller needs to claim that they cannot move out because of the circuit breaker. All right. Contractually, all right, it is provided for in all residential contracts or transaction contracts that on the completion date, the seller has to deliver vacant possession. And vacant possession itself means that the place has to be vacated, all movable furniture out, all human beings out of the premises, right? And the premises handed over to the buyer. Right. Further questions on such scenarios would be, what can the seller do? Right. If you are a seller or you happen to know of a seller that's in this situation, there is nothing the seller can do. Right. Legal, properly, right. So what we will always advise sellers in such scenarios is, if they can, all right, talk to the buyer, right, to ask the buyer whether he can help out. If the buyer is not willing to, then the seller has to actually look for alternative accommodation, like a short-term rental somewhere else, move in with their parents, their relatives, or their friends, right? Simply to satisfy the requirement to vacate the premises for the completion. Right.
Okay. Now, so this came to a deadlock situation, right? So we know at times people try to negotiate, but if let's say you're talking about a Chinese buyer, for example, wanting to move in to renovate because the 7th month is coming, yet wanting to give way to the seller, yet the seller right now says that, you know, they have enough time to move out if it actually ends on the 4th of May, but now it has delayed for another 4 weeks. So how are they going to look for a place? Doesn't make sense. And then to look for a place for another 1 year or 2 years, they're going to rent a place and going through online. There are only so little possible online view, right? People actually, where the agents actually go down and have an entire 360 degrees tour of the house. So they're just basically committing to a unit just like that. And to them, it doesn't make sense with young children and all. So it comes to a real deadlock, right? And then they get frustrated and they say, since the buyer is not willing to do it, then never mind. I'm just not going to turn up for the completion date. Is it something that the seller is able to do? Can they just don't turn up for the completion date?
Okay. Let's say it comes to such sort of a deadlock, like Darren has explained earlier, and the seller says, okay, I'm just going to be very stubborn and unreasonable about things, right? I'm not going to turn up for the completion. I'll tell my lawyers that I'm not going to complete on 3rd of June, right? Now, contractually for HDB or private property resale transactions, all right, if on the date of the completion, there is a party that is not able to complete, and in our example here, the seller has chosen not to complete, all right, then there is recourse for the party that is innocent. In this case, it will be the buyer. So what the buyer can do is, first of all right, through the lawyers, right, send a notice to the sellers, all right, to state that, look, right, today the buyers, we are ready to complete, all right, whereas you as a seller have claimed that you are not ready to complete, or you appear to be not ready to complete. So therefore, based on the contract, all right, the first recourse the buyer has is to charge, all right, the seller, all right, late completion penalty. So how does late completion penalty adds up, right? Now, if it's a HDB resale case, all right, the HDB resale option to purchase is subject to the Law Society's Conditions of Sale 1999. Whereas for private property transactions, all right, the option to purchase is subject to the Law Society's Conditions of Sale 2012. All right. Simply explained in layman terms, the Law Society Conditions of Sale is like a guidebook. All right. In it, there are many scenarios given as to what the recourse could be if such certain scenarios should happen that doesn't allow a smooth completion of the transaction. Now, for HDB transactions, all right, say a seller decides to say, okay, I am not going to cooperate, I will be unreasonable, I'm not going to complete the transaction. All right. Straight away, what the buyer should do or can do through his lawyers is to issue a letter to the seller to say, okay, like I explained earlier, we, the buyers, are ready to complete. You, the seller, is not ready to complete. All right. First recourse is to charge late completion penalty. So the late completion penalty for HDB transactions is at 10% per annum on the property price. So say, for example, you have a $500,000 property. Okay, let me just punch on the calculator. So $500,000 property, all right, the seller is not able to complete. The late completion penalty is at 10% per annum. So you times 10%. All right, so on an annual basis, it's 50,000 divided by 365 or 366 because this year is 29. There's 29 days in February.
All right.
So for every day that the seller cannot complete, all right, the buyer can charge $136. Right, so $136 every day, all right, to be charged by the buyer on to the seller for each day that there is no completion. And this adds up $136 per day, all right, until the actual date of the completion. So for the buyers, the first thing is to charge a late completion penalty per day. If it's a private resale property, all right, the late completion penalty is at 8% per annum, not 10%, 8% per annum. So same thing, you take the purchase price, you multiply by 8%, then you divide by the number of days in the year, right, to derive the amount, the compensation per day, all right, for the buyer, right? So this is first recourse. Second thing that a buyer or a seller can do is this. If the buyer thinks, well, this seller is very unreasonable, all right, he's going to probably be unreasonable and going to continue to delay the transaction way past maybe 1 month or 2 months or 3 months until such time he thinks he is ready to move up, right? Is the buyer not able to do anything else? The buyer can, all right? So same thing, based on the Law Society's Conditions of Sale, right? Be it whether it's the 1999 version or the 2012 version, right? The second recourse that the buyer has is to also serve a notice on the seller to say, hey, look, today is the June 3rd, all right? 3rd of June, you're supposed to complete the matter. You have failed, you have refused to complete the matter. I have already informed you now. I will inform you now that there is a late completion penalty on a per day basis. And the buyer can serve to the seller a 21 days notice to complete. So what's the 21 days notice to complete? Basically, the moment this letter that says, I, the buyer, give you, the seller, the party who cannot complete, 21 days to complete, all right? You must complete, all right? So at the 21st day, right? So June 3rd plus 21 days is like June 24th. So on 24th of June, if the seller still does not complete, all right, what the buyer can do is to speak to the seller or to inform the seller, okay, I've given you the notice, 21 days is up, all right, you have still failed to complete on the 24th of June. Therefore, the buyer can then walk away from the transaction, right? Okay, but of course, this is only provided if you as the buyer, all right, is looking at terminating this transaction, all right? So you serve the 21 days notice, and at the 21st day, you can then walk away from the transaction. You can don't compete with this unreasonable seller anymore. So, looking at it, all right, whether or not you collect the late completion penalty or whether you serve the 21 days notice, right? These are contractual release that the buyer has. But of course, in every transaction is different, all right? It depends on the buyer. If the buyer says, no, actually, I really want the house a lot, all right? But I don't mind. $136 a day on a $500,000 HDB. So if you think about it, $136 a day, you multiply by like 30 days, it's going to be like $4,000 worth of completion penalty. So in a way, if the buyer is also not in a rush to go move in anyway, because of the circuit breaker, as a buyer, even if you take over, you might not have contractors who can start work as well, right? Right, the buyer might elect to say, okay lah, then I will just serve the notice to collect the late completion penalty, and then I'll just collect it until the day he decides to complete lah, right? Which is quite a substantial sum as well, right? If you think about it, if you rent out the place, usually we talk about rental returns, we say 3%, 4%, or 5%, right? This is like 8% or 10%, all right, per annum. So it's definitely monetarily is worthwhile for the buyer, but of course, different buyers have their different needs. Some that actually need to get the keys earlier to move in, or they're intended to move in, all right, without renovating the place extensively, would then be inconvenient. But then again, if you look at it, you collect compensation here. If you can arrange for alternative arrangement somewhere else, right, it sort of really compensates the aggrieved buyer in that sense.
Okay, maybe in terms of more a little bit deeper, right? In a case, for example, they really wants to complete it, and that's why the buyer bought. If not, the buyer walked away. He serves 21 days notice to complete the property. Now comes 24th of June. The seller now must pay over $4,000 in terms of late penalty charges, and I'm sure this will be in cash, isn't it?
Yes, correct.
Yes, in cash, right? But how many 21 days can the buyer serve before he brings this up to court to complete? Or the 21 days is going to be final, you have to complete, and this is in terms of, it's a court of law, you must complete.
Okay, in terms of the 21 days notice, you can only serve it once, all right? So it's just one time of serving, and to be clear on it, at the expiration of the 21 days, it actually gives the buyer, the party who is innocent, the right to actually null and void the transaction, right? So what Darren mentioned earlier is, say at the end of the 21 days, if the seller still refuses to complete, can the buyer then take the seller to court? Yes, all right. First of all, it's going to high court because the value of transaction is high, all right, and you will appear. Both parties have to appear before the high court, right? The judge who will then give a judgment, all right, to evict the seller and to compel the seller to complete. But then again, we need to understand the process of suing such a seller in a court, all right? Usually, it will take you 3, 4, or 5 months before you probably get a hearing date. So if the seller is not in moving out or completing because of the circuit breaker, or because of the current circuit breaker issue, chances are by the time, even if you want to bring him to court, he would have already completed and shifted out already, right? So that's something you need to think about suing.
I see. Okay, so right now things really go to the extreme. Okay, guys, I'm trying to give you all the extreme so you all will know that what could be your legal rights at this point in time, right? If you really want to complete and the seller doesn't want to complete, right? So after serving the 21 days and then going up to court, all the additional legal charges, can we actually charge all to the seller?
Actually, no. All right, so okay, I just need to clarify on this point as well. So a lot of times people will say, hey, I'm the innocent party, I want to sue another party, and if I win this case, I want him to compensate all my legal fees, right? The court does not does not work in this way, or rather cases don't get settled this way, all right? Yes, you are the innocent party, you sue the other person in court and you get a judgment in your favor. Now, what the court does is that the court cost, right, to the winning party. So, for example, if this case took maybe 2 or 3 months and required the innocent party's lawyers to do this much work, right, to appear in court this much time, right, the court will then say, okay, the party that is wrong has to deliver, all right, whatever that is supposed to deliver, plus cost to the party who is correct. And this cost is assessed and given by the court. So it could be a figure like 1,000, 2,000, 4,000, right, depending on the assessment of the judge. Whether or not, all right, it's sufficient to pay, all right, all the winning party's legal fees, chances is no, right? No. Why? All right. In litigation cases, all right, the legal fees could be maybe $4,000 or $5,000, say for example, but the cost awarded for this case by the courts could be like $1,000 or $2,000, all right? So that difference, right, the winning party will then have to pay to his lawyers. We call it the solicitors and clients cost, all right? The other simple way for you to understand is this, all right? If you hire a lawyer, all right, and the lawyer decides to look at the case and say, wow, this is a very good case, and then tells the client that, oh, you know, I'll charge $10,000 for this case. So it doesn't mean that the court will give you whatever your lawyers decided to charge, all right, and to make the party who is wrong to pay for all those legal fees. So there is a cost that the losing party has to pay, right? But how expensive the lawyer is, all right, that difference you have to pay as the winning party.
So give me a round figure. If someone's working with Crossborders LLC, the serving of 21 days is part of the conveyancing, isn't it? Or is there an additional cost to that?
If we are representing either the buyer or seller, the serving of the 21 days notice is part of our package work.
Package work, right? And if it doesn't work out, you have to go further to the High Court. What is a round figure you can actually
I think if it's going to be High Court, usually you're looking at $20,000-$30,000 upwards.
I'm sorry?
You're looking at $20,000-$30,000 upwards if it's going to be a
for a $500,000 property to bring the seller to court is 30 grand.
It's up there.
Oh dear. So I think the best thing that lawyers will always say is try to be amicable and try to give way.
Yeah, actually, like I explained very much earlier in this session, all right, because of the circuit breaker and because how the circuit breaker keeps getting extended, if you look around the world, all right, many countries that have started the equivalent of our circuit breaker, all right, they have, you know, extended it a few times. You look at Malaysia, they're like their third or fourth extension of their movement control order, all right. Yes, it has brought about a lot of upset for a lot of residential property transactions. If you look back at the last one over month, MINLAW, MPI, all right, all the ministers that have been coming up to announce reliefs, right, whether in terms of salaries or for commercial tenants or for businesses, nothing has been announced, right, for residential property transactions. All right. Why? All right. I don't have an answer to that, but because there is no temporary reliefs being announced for residential property transactions, so therefore for residential contracts, it is business as usual. All right, everyone has to abide by all the terms and conditions in the contracts.
Okay, but anyway, good news is that so far in my past 15 years of doing selling and buying, rarely, I've never been to court before. Okay, so
it's very rare.
I think this one is very rare. Yeah, it's very rare.
Okay, it's very rare. I think if you do a Google search online, there are some public cases, right? But then not many. I mean, not many cases end up in court, right? Great. When you talk about buying and selling transactions.
All right. Okay. There's a comment that just came in. All right. This is by Sheikh. Thank you for your question. And his question is this: what do people do when the buyers do not honor the extension stay despite agreeing during the purchase? And what is the proper channel to exercise the buyer's right as a seller to stay? Sorry. What is the proper channel to exercise the seller's right to stay for the period of 3 months? So this is a case whereby they've agreed on a 3-month extension upon the completion, all right? And then right now, after in possession of the keys, they decided to say, I'm sorry, I've given on my word, I want the sellers to move out now. What are the recourse possible for HDB transaction and for private transaction?
Okay, so let me just understand the question correctly. You have a seller now all right, who agreed to give a 3-month extension.
The reverse, the buyer.
Yeah. And or seller who wanted a 3-month extension and the buyer initially agreed, but now the buyer is saying, I do not want to give you that extension anymore.
That's
okay.
right.
First of all, I want to say the seller is staying in the house, correct? So as a seller that's staying in the house, all right, if you don't move out, then how can the buyer come in, all right? So
he goes for the completion. He still goes for the completion. So they agree completion as per normal. After they complete the property, right? And he says that, no, sorry, I don't want to, you cannot extend, please move out within a week.
Okay, so let's assume for simplicity's sake, this seller says, okay, since you don't allow me to extend, I move out. All right. So in all contract cases, all right, when there's a party who is wrong, all right, the party who is innocent, all right, when we want to sue, all right, the party who caused the wrong, all right, we always have to be able to quantify the losses. All right. Say for example, in this case, if the seller initially was supposed to have a 3-month extension. Now the buyer says, I don't want to give it to you. And all this was actually in black and white and already approved as in the case of a HDB resale, right? What the seller can do is to put it upon the buyer that, look, if you don't allow me this 3 months, I will incur expenses, all right, to rent a place or to rent a place somewhere else, all right? So I would want to claim, I reserve my right, right, to claim, right, this 3 months worth of rental from the buyer. Now, I just need to qualify here as well, all right? The seller who claims for this rental must actually incur a rental, right? This seller cannot say, oh, move out, move in with his mother or his siblings, incur no rental cost, and then claim it on the buyer, right? You can't, right? You actually need to, at the end of the day, prove that you incurred, right, an X amount of losses, right, because of this buyer's actions.
Okay, okay. Also, that is the only recourse for the seller, is it? They have to move out. Now, is there a possibility, or what is, okay, now we have covered the seller side. Now let's reverse the condition. The buyer wants them to move out. The sellers is adamant and they want to stay put and they don't move out even after the legal completion. What can the buyer do?
Okay, so given the same understanding, both buyers and sellers agreed initially when the contract was formed that there will be a 3-month extension. Now the buyer says move out, all right? And the seller doesn't want to move, all right?
That's right. He's just saying that, no, maybe this is 3 months. I'm 1 month into my 3 months. Now say no, please get out.
No. The buyer can't do anything because at the point in time when the contract was formed, all right, be it whether it's the option to purchase for HDB or option to purchase for resale, at a point in time when the contract was formed, this was already an agreed term, all right, for the transaction. So the buyer cannot then say, I do not want to give you this 3 months anymore. You can't. It's like, you know, there are so many terms and conditions in the option to purchase. You can't help it through the transaction, right? Seller tell the buyer or buyer tell the seller, hey, I want to change the purchase price, or I want to change the completion date, all right, without the other party mutually agreeing on. So the extension of stay is a agreed term in the contract, all right? So the buyer can't tell the seller to move out and expect the seller to just agree to move out.
So this is where on the ground we have some conflicting views on that, because if we look at the HDB documents, right, it's very clear to state that there is no other supplementary agreements to the OTP. And if they were to even agree with the extension, this is a mutually agreed stuff. If there's any conflict, right, they solve on their own, because it is also agreed that buyers, upon agreeing the 3 months, they can also reserve the right to withdraw that 3 months after that.
I don't know the part about whether buyers reserve the rights to cancel the 3 months, right? But what I'm pretty sure is that HDB generally does not want to get involved in disputes. So at the end of the day, for HDB, right, after so many years, for HDB it's a simple, it's a straightforward case. Okay, they will handle it. The moment there is a possibility of a dispute, they will just discharge themselves and tell the clients, hey, well, you're going to consult your own lawyers. So I'm explaining to you from the contract point of view, whereby if there is really an agreement, all right, given and agreed on by both parties, all right, the party that does not perform will have to compensate the party that is able to perform, right? Be it whether it's late completion or be it of not giving a 3-month extension of stay.
Okay, so let's make it a bit extreme. So you are saying that if there is agreement given to the sellers to stay for the next 3 months, and after a month, the buyer's asking them to move out, they are not moving out, and then the buyer call the police up, and then the sellers show the policeman that say, hey, this is actually already given by my right? What can the buyer do about it?
Okay, first of all, when you call the police will not do anything because this is not criminal. All right, it's not a criminal. There's nothing criminal about this. All right. Plus, you have all the paperwork to support that. As the seller of a property, you have completed the transaction. Yes, you are no longer the owner, but you have an agreement, right, to allow you to stay. All right. They will just tell you, okay, this is a civil case. Go and consult your own lawyer. That's what the police will do.
Oh, so the buyers then cannot chain out the lock. Okay, now let's go a bit extreme. Now the buyers are very upset and they chain out the gate.
Okay.
Is this a criminal offense with the buyer?
Yes, actually, it is actually not correct, all right, for you to chain up the doors to a property, all right, that you have no access to, all right. So say, for example, the buyer in this case chains up the door. It is actually wrong, all right, for the buyer, because this is confining someone in a property, all right, unlawfully. Right, so it is actually a criminal offense. So if the police get caught in for this, the police will actually demand or cut the lock. Right, and I would suggest also I would suggest that no one does this, because you got to think about it. What if you chain up the door, right, and someone is inside, and then a fire breaks out, or there's an emergency and the person cannot exit them? If it leads to death, all right, then that's, I think, manslaughter as well. So we shall not want to go down.
This is good advice. Yeah. Yes, definitely. Yeah. Okay, so guys, if you have just joined us, okay, this is Ted Koh from Crossborders. He's here to answer all the questions. So I hope this clarifies your answer, Sheikh. All right. So moving on to the next question. All right. What happens if, for example, there is a loss of title deed? All right. I know in the past, private owners and HDB owners, they do own the title deed. And right now, I think SLA and HDB holds on to them because there have been many cases of individual and families losing their title deed, right? So is this going to cause a delay in the completion? And then the next question is that how much is the cost to do the new title deed again?
Okay, maybe I'll answer the cost first, so that those of you with fully paid properties will probably listen up a bit more. The cost to get a replacement title deed through the lawyers generally is around the range of $4,000 to $5,000. So it's a lot of money. All right. If you lose the title deed and you are selling a property and you need the lawyers representing you to go and apply for new title deed, it will cost you about $4,000 to $5,000 plus. All right. It takes time, right? It's not something where you can today walk out to the Singapore Land Authority's office and say, hey, I lost my title deed. Can I get a new one? And then they print a new one. That's not going to happen. All right. So what's the process? Now, like Darren explained earlier, all right, for fully paid properties, all right, in the past, SLA would release the title. All right, so be it whether it's a HDB property or a private property, right, the Singapore Land Authority will release the title, all right, when it's fully paid. So how do we get to this stage? Now, most people buy a property with a loan. So when you buy a property with a housing loan, all right, on the completion of the purchase, all right, what happens is the lawyers representing you in the purchase, right, will take the title deed and then, in short, send it to the bank that you took a loan from. Right, the reason is because a property loan is a secured loan, and security comes from the bank having an interest on the title of the property. So that's why, for those of you with a housing loan, right, you don't have the title deed. Right, the title deed is kept by the bank. But the bank will keep it, all right, until the day the loan is fully paid. So for those of you who have fully paid loans, fully paid a housing loan off before, all right, upon the payment of the last installment, or if you actually write to the bank to say that you want to fully pay off the loan, the bank will say, okay, all right, the loan is to be fully paid, right? It's going to be zeroed, all right. Now, can you get lawyers, right, to redeem the title? So to redeem the title means you get a law firm to write to the bank, right, to take the title back. Now, when we take the title back, when the law firm takes the title back from the bank, this title deed, this original title deed will then be sent to SLA. SLA will destroy it, right? And they will reissue a new title deed. The reason for destroying that title deed is because on the title deed that was held by the bank, it had the bank's interest. So on one of the pages, it would state that the bank is a registered has a registered interest on the title. So this title has to be destroyed, and a fresh one, right, without the bank's interest will be issued. Now, in the past, SLA used to issue the title, all right, back to the owners of the property that had fully paid off the loan, right? But like what Darren explained or said earlier, a lot of owners actually replace it, all right? Why they replace it? Like the day they repay the loan, the day they get the lawyers to go and get the title, the lawyers will hand the title to the owner. The owner, it's a few pieces of paper, all right? It's probably just like that, a few pieces of paper in an envelope, all right? The owner will bring it home and then just chuck it somewhere, all right? And they will not think about it anymore because it makes no difference to them. The house is still the same, right? There's nothing has changed, right? Regards to the access of the house or how the house looks, right, after fully pay off the loan. So they will chuck, right, that document, right, aside. And many years later, when they decide to either remortgage the property or they decide that they want to sell the property, all right, the lawyers, all right, that represent them say, hey, Mr. So-and-so, you know, you had fully paid off the loan, and we understand that the original title was actually given to you, right, by the lawyers that redeemed the loan. Now we are transacting the property, all right? So when you transact the property, you need to hand that title deed to the next buyer, right? Can we have the original title? That's when a lot of sellers went, oh, I don't have it. I cannot locate it. I do not know where it is. Okay, from this point in time, all right, that the seller, the owner, who is now a seller, comes to realize that he has lost the title deed, right? And he informs the lawyers, right? It would take roughly about 2 to 3 months, all right, to apply and then to receive a new title. And it's also subject, all right, to SLA's approval. So the process would be the lawyers will draft up affidavits. Affidavits will need actually documents where the owner will need to swear to state, oh, this is the sequence of events. I paid off the loan. For example, I paid off the loan. I took it home. I took the title deed home, and I misplaced it. I've never seen it thereafter. All right. Okay. We need to get the lawyers who discharge the loan to also do a simple affidavit, a simple statement to state that yeah, they had retrieved or took the title from the Singapore Land Authority and passed it to this owner, and the owner makes a statement that he has lost it. Then in some cases, SLA might want a advertisement to be done, right? So we need to put advertisement on the Straits Times classified, right? And the application form has to be submitted to the SLA, right? Internally, ding and dongs, all right? And 2 or 3 months later, if it's approved, then SLA will issue a replacement title, all right? Now, how it affects property transactions is this. The usual time frame, don't talk about now during this circuit breaker period, the usual time frame for most property transactions from the time the agent finds a buyer for a property. So say you're a seller, the agent finds you a buyer, all right? If it's a HDB transaction, all right, the seller, there's 21 days option period, and then once the options are exercised, you do a submission, and then 8 weeks later, you do completion. So all you're looking at about maybe 2.5 to 3 months. For a resale transaction, the usual time frame is like 2 weeks option period and then 8 weeks to exercise to complete. All right, so 2 plus 8 is about 10 weeks. All right.
This is for private property, you're saying?
Private property, correct.
Property,
so whether HDB or private, but you're looking at about 2.5 to 3 months time frame, all right, for the transaction to complete. Now, usually the sellers or the agents don't ask the question of where the title is, all right, at the very beginning, because no one expects the seller to not have the title or to have lost the title, right? Usually it comes to the point where the law firm, when we contact the owner, who is the seller, and we request from the seller, because we look from, we notice from the title documents, the title search that we do online, that it's a fully paid property, and then we ask the owner, hey, could you come by, or do you still have the title? In fact, a simple question, do you still have the title? That's where a lot of owners will start to scramble. They say, hey, I can't find it. So by that time, usually we are maybe like 6 weeks away from the completion. So given that the application for a fresh title takes about 2-3 months, if we're 6 weeks away from completion, that will mean that the seller here, all right, will not be able to be in time for the completion usually. And the most important document a seller needs to produce for the completion of a sale is the title deed. If the property is still mortgaged to the bank, the lawyers representing the sale will get the title from the bank.
Yeah.
But if there is no housing loan, then the owner or the seller has to provide the title deeds to the lawyers, right? And no buyer or no lawyers that represents a buyer will complete a transaction, all right, if they do not receive the title, all right, from the seller on the date of the completion, right? So definitely there's no completion, and it is not the fault of the buyer, because the buyer is ready. The buyer has all the money, is ready from completion. Now it's the seller's fault. The seller has no title for the completion. So same goes, all right, that late completion penalty, right, will be calculated on the per day basis, right, until the actual day of the completion. So the seller, right, who has lost the title will need to pay that late completion penalty, plus, right, you need to pay the lawyers to get a replacement title, right, to complete the transaction.
Okay,
So
would this be the same issue for a property that's passed on and then they lost the title deed?
Okay, it's
wise?
Okay, it's
means
quite
the cost of getting a replacement will also be about $4,000 to $5,000.
Yes, all right. It's quite a common occurrence where you have a property, right, where the previous owner passed away, and then that property, whether by will, right, to a beneficiary or intestate to a beneficiary, and the title deed cannot be found. And there's no way you can ask the dead person where the title deed is, right?
Of course, yeah.
Passed away, all right? So what happens is you need, as a beneficiary of the property, whether it was given to you through a will or because of the Intestate Succession Act, when the lawyers do the change of name to the beneficiaries, the title deed also needs to be produced to SLA. Remember I explained to you earlier, the title bearing the interest of the previous owner or the bank needs to be surrendered to SLA. SLA will destroy and issue a fresh title in this case, the beneficiary's name. If the beneficiary cannot locate the title deed, then yes, the cost, all right, to replace the title is also the same.
Okay, good. All right, so guys, if you have any of your properties already fully paid off, and then right now you kind of cannot remember where is it, I hope it's in the safe deposit box, all right, in the bank, or it's somewhere in the house that you can locate. And if you're thinking of writing a will to pass it down, please make sure that all these documents are very important and is kept somewhere. All right.
Okay.
And the last,
Darren, let me just add on to one part. Okay, so just
sure.
to update everyone here as well. So since, if I'm not wrong, 2013 or 2014, all right. What SLA has done is this: they have introduced the suppressed title system. So what's suppressed title system? So if you've fully paid off your housing loan, right, but if you had used CPF money towards the payment of the property, so this is how it goes. You buy a property, and then you had used CPF monies, whether for the stamp duty, legal fees, or the up and down payment, or the monthly installment, all right? And after X number of years, you fully pay off the housing loan, all right? Now, fully paying off the housing loan means that you have paid off the bank, but your CPF monies are still in the property. You can follow, right? So if your CPF monies are still in the property, right, since 2014, SLA will no longer issue the original title to the owner, all right? They will suppress the title, meaning that they will keep the title in the Singapore Land Authority, in the registry. Actually, they do not issue the original title at all.
Okay,
right?
is there a way for our HDB friends or our private owner friends to, those that already paid off, how are they to know whether they have the title? Is there a way they are able to check?
Okay, there's two parts to this question. First of all, Singapore itself, okay, let's understand what the title deed is and why the title deed is so important. Now, back in the days, we're talking about 100, 200, 300 years ago, all right, there is no internet, all right, there is no hard disk, there is no cloud storage, right, there is no database, all right. The only way, all right, for a person to identify himself is with a physical document. The only way for a owner of a property to state that he is the owner is if he produces the physical title to the property. So that's how title deeds come about. If you guys have watched shows from the 60s, 70s, 80s, right, they talk about title deeds being a very important document. All right, this is still a very important document, but the purpose of the title deed, right, has not changed. Right, but back then they had no internet, there's no database, there's nothing. Right, so owner needs to have the original title deed, all right, to show the world, to be able to inform the world that he or she is the owner of a property. Right. Currently, these days, right, especially for the last maybe 20 years, all right, the Singapore Land Authority has moved to a digital platform. Right. So these days, in order to find out who or to confirm who the owner of a property is, you don't actually have to go up to the owner and say, hey, show me your title deed. All right, you don't have to. All right. What happens is we can perform online searches. All right. So if you go to the SLA's website, right, you can query on online search on ownership of the property. All right, you pay like $15, right? You can pull out the records of who the owner of a property. So key in a property address, and it'll show you who the owner is. Right. Additional information in this title search itself would be whether there is a housing loan, whether CPF monies have been used. All right, whether the owner has pledged the property to a third-party lender or such, or whether there's any adverse interest that's registered on the title to be a bit more technical about things. All right, so the point is, right, as the owner of the property, you don't need to show the physical document to state that you're owner. All right, search online, all right, which is very, very updated, all right, all the time, right, is sufficient, right, for a person who is asking whether you're an owner, all right, to be able to prove, to satisfy, right, the question of who the owner of the property is, and also to satisfy the question of whether the property is fully paid. All right, so that's why that's probably also why SLA has taken this step where if there's if CPF monies are still being, or CPF monies have been used and is still in the property, right, they will suppress the title and they will not release the title. So looking at it, I think it's a very good move, right? A lot of people can fully pay, right? But because most people use the CPF money. So unless, besides fully paying off the housing loan, you also repay back all the monies to the CPF account, right? Whatever you have withdrawn plus accrued interest. It's not these days, it's surprise title. You will the owners will not get the physical title to the property, which is good as well. Because if you think about it, getting that few pieces of paper, all right, is quite a bit of liability. It serves there's no added benefit of having that piece of paper. It's not like you can paste it on the door, you can do something with it. I mean,
some people are just traditional. After so many years at payout, I just want to feel shocked to hold a title deed in my hands, right? So they can just go to SIA to check whether they have their titles with them, or is it with SLA or is it with them? Is that what you're saying?
You don't actually need to go to SLA itself. Actually, you can go to any law firm, right, that does property transactions, ask them to perform the search. The search fee is about $15 or $16. All right. Probably charge you a small admin fee of $10, $20 to print you the result of your title search on your property.
Okay, so you will know whether if you had it or it's with SLA, is it?
Yes.
So
correct.
if you know that it is with you, then you better get and search all your boxes to find out where's your title deed, right?
Correct.
Right. Okay, good. All right. So if you guys just join us, this is Ted Koh from Crossborders LLC, giving us live right now. We're meeting him to share with us whatever knowledge that he has. And if you have any other questions, please come on board. Ask your questions, right? There is no, it's FOC, so don't have to be shy about it. Just ask him if you're facing any things that you're unsure of or you need some clarity. All right, this is the most neutral person that I know. He shared with you professionally what can or cannot be done in any of your property transactions or any issues that you may or may not have been facing right now. Right. So if you move on further right now, I want to just move into something which is very, very common in today's market, whereby salesperson are actually advising their customers to do two things. Number one, either to decouple the property so as to buy another property, and then the second is to buy a property under a trust. All right. So I want to go into the first one first. Ted, what are your thoughts about decoupling, the process of decoupling, the legal cost of decoupling? And if in your experience, is there any other things that you think that in this particular strategy of decoupling, things that maybe that you have actually came to know about that you think that it makes sense to share with everyone here?
Okay. I will answer the question about cost last. All right. So let us understand what decoupling is about. Now, the market uses the term decoupling, but in our industry, right, we actually use the term part sale and part purchase of a property more. Right. So what do we mean by decoupling or a part sale and purchase of a property? Now, most of the time when a property is being transacted, right, the whole property gets sold or the whole property is being purchased. So when we say whole, all right, for those of you who can understand the concept of whole, is equivalent to 100%. Right. So 100% gets sold or 100% gets bought. All right. But there are situations where not the whole property is being bought or sold or bought. All right. We look at half the property being sold or half the property being bought. All right. This is where we call it a part. So it's not a whole. It's a part sale or a part purchase of the shares in a property. Now, why has there been so much interest in a decoupling or part sale and purchase of a property? All this or most of it came about because of additional buyer stamp duties. So since 2011, if I got my year correct, right, the government introduced additional buyer stamp duties. So what happens is when a person purchases a property, all right, or when you purchase a property, you need to pay, or rather, additional buyer stamp duties needs to be paid. Sorry, so buyer stamp duties needs to be paid. But since 2011, additional buyer stamp duties has been introduced. So currently, today, if you are a Singapore citizen and you're buying your first residential property, you pay the basic buyer stamp duty. So there's no additional buyer stamp duty. But if you're looking at buying a second residential property, meaning you currently own one and you want to buy another property, this second property, all right, would incur 12% additional buyer stamp duties. All right. So the only way where you can purchase this property without incurring the 12% additional buyer stamp duty is if you get rid of the first property. So when you have gotten rid of the first property, then this purchase is not a second property. It is a first property, and there is no additional buyer stamp duty. All right. So what happens is, or what's happening on the ground is, most cases, all right, a residential property that is owned by husband and wife, right, when they bought it, like 5-10 years ago, they bought it in both names. Let's say 10 years ago, because there was no additional buyer stamp duty. But these days, of course, people structure property ownership in a different way. So 10, 15 years ago, people would buy a property in husband and wife name, or even 5 years ago. Reason for doing so is we are Asians, and it's very traditional for Asian families to, or married couples to buy a property together. Also, all right, when you buy a property together, you can use both parties' CPF monies, and you can use both parties' income to qualify for the housing loan. All right, and use both parties' CPF monies for monthly installments. So most people, most married couples will buy a residential property, their first property together. Now, many years have passed since this purchase, and they now decide that they want to buy another property. But because both of them have a name in the existing property, so be it whether they buy the next property together, or one of them, either one of them decides to buy the next property, it will be that property purchase, that second property, that new property purchase will be subject to 12% additional buyer stamp duties, right? So like I explained earlier, the only way to not incur additional buyer stamp duties on this new purchase is if one of them exits from the existing property, right? So to get the concept correct, right, you have husband and wife, they co-own a property, right? And one of them is to exit from the property. So when you exit, right, now, husband is 50% owner, usually 50%, wife is 50%. In order for the wife to exit, this wife's 50% needs to be taken over by someone. So in this case, it is the husband. So that 50% that the wife has will go to the husband. And the husband will buy over the 50%. The wife now has zero, no shares in the property, and buys the next property as her first property. So that would be a first property. It would not be subject to ABSD. So this is, in short, the concept of a decoupling. One of them is decoupled away from the existing property and therefore buys the next property without ABSD.
All right, let me just interrupt you a while for now. So guys, this is what Ted is sharing with you, the process of decoupling. All right, for him, he represents a law firm. So this is what he's sharing with you in terms of the technicalities of what a decoupling is all about. But after saying all this, also keep in mind that there's another component you have to be very clear about. That is called the financing side. Right, this is where Aloysius came in last week to actually give you some thoughts on how to get the financing. So it's two different things. All right, it's not because you know the strategy or decoupling you can do it, because it also has to come with financing to purchase the other property. All right, do not go ahead and try to do it on your own, because if you didn't plan the financing correctly, it might be stuck. And if you have already purchased the next property, you'll be in a worse situation. Okay, right.
Okay, so maybe let me do some sales pitch here, right? You can't do a decoupling of a property yourself, all right? You will need to engage a law firm to do it for you. So actually, the first step, if you want to do a decoupling, would be to go to a law firm. So you can come to Crossborders. So what I'll do is this, all right? During this circuit breaker period, you can get my number from Darren, all right? You can WhatsApp me, tell me about your scenario, all right? I'll ask you a few basic questions. In order to do a decoupling, we need to know first the value of the property. So what's the existing value of your property? We will need to know how much loan, what's the existing housing loan amount. We also need to know how much CPF monies have each of the owners used. And we also need to know how much CPF monies is in the ordinary account of the owner who is staying behind. And what I'll do is I will be able to do a quick calculation, all right? You don't need to tell me your income, all right? I know it's very sensitive, all right? So I'll do the calculation for you, right? And then I will tell you based on the figures that you've given me, in order for you, for the person who is going to stay behind to own the existing property fully, or estimated what sort of income this person must have in order to qualify, right, to take over the loan. I also work out how much cash or rather the finances that's required, right? You can get my number from Darren for this, all right, and then just, or you can go through Darren. Darren can give me the scenarios, and then I will just do a calculation for you, or I think Darren can do the calculation as well.
Normally, guys, you know that I will do all this for you first, right? I will calculate your next purchase, the loan you will get, so on and so forth, how to keep aside your crisis fund before we meet up with Ted, right? But then I've also promised everyone, every single guest speaker that's coming on board to my group, they are Ted will be coming in to join this group too, right? So you have access to him directly. He also leave his number in a while later for you to call him directly. So he responds better via WhatsApp when you call him, because sometimes he's always engaged on the line with someone. He doesn't answer the phone. But during the WhatsApp, he replies because he's smiling now. Because whenever I call him, he don't answer the phone. Okay.
Yeah. Before you get my number, I just want to qualify first. For the last, I think, 10, 15 years that Darren has been working with me, since the days before you don't have iPhones or smartphones, the common complaint about Ted is that he never answers the phone. But then I always reply this way. See, I'm talking to you guys. I've been talking to you guys for the last hour plus. All right. I've not answered any calls. All right. There have been people that have been trying to call or text me, but just leave me a message. All right. WhatsApp. All right. I will definitely reply to you once I get the chance to.
All right. So now we go into the cost. What's the cost of decoupling?
Okay. So a decoupling of a property is, like I explained to you, there's a selling. So one person is selling and one person is buying. So it's two transactions, all right? There's a buy and a sell, right? For if the property value is below $2 million, we're looking at about $5,000 for the legal fees, for the buying and the selling.
For the legal fees only, yeah. So we're not talking about the rest of the add-ons yet, right?
There'll be mortgage stamp fee. There'll be the stamp duty. So that stamp duty is based on what the value of the property is, which we can only work out when we have the value of the property.
I see. Okay, thank you. Okay, next thing that I think has been a lot of people's mind, and I think a lot of companies, even mine included, all right, has been sharing this skill set of getting people who has already utilized both names, husband and wife, and now having some extra cash, all right, are looking to buy a property under trust, all right, and I felt that the whole terminology of the trust has not been fully explained, whereby buyers are able to make a better decision for themselves. And when they already purchase it to the developers and then they meet the lawyers, okay, I think a lot of them doesn't understand when they can really exit when they buy a trust, all right, and what is the meaning of a trust in a whole, in a nutshell. So I think, Ted, are you able to clarify? Because a lot of us are selling. I myself have sold a property under trust, all right, but I advise correctly, okay? So I just wanted you to give your professional input to our viewers here. What is buying a property on trust all about?
Okay, maybe I'll just take some time to explain or rather clarify what a trust is. Okay, a common or my favorite question to seminar attendees would be this. Just imagine, all right, if your grandfather or your great-grandfather had many years ago, all right, set up a trust, all right, and name you as a beneficiary, all right. So say, for example, 80 years ago, all right, your grand or great-grandfather had set up a trust and named you as a beneficiary, all right. What's going to happen is today, all right, you are going to be living off or to be able to live off, all right, the monies or the properties that your grand or great-grandfather had put into the trust, all right? So what is a trust, all right? Now, on one hand, we have money. So this is money, all right? On the other hand, all right, we have the children or grandchildren or great-grandchildren. Now, traditionally, all right, families that are rich or individuals that are rich, meaning that they have monies that can last many lifetimes, all right, they will look at setting up a trust to benefit their future generations over here. Now, there is money here, there's a future generation here. Now, in between, let my face be the in between. All right. So there is a direct way of giving the money. So monies can go to the future generation. But if it goes to the future generation directly, the future generation gets hold of the money. They get to decide on how to spend the money, right? So that's where if you give $1 million to a young kid, he might spend $1 million to buy a Ferrari, right? So what a lot of the well-heeled clients or the traditional rich will do is they have the money, they have the future generation, but they don't want the money to go directly, right? So in between, so money, future generation, in between, they will put a person, right? This person is the trustee, all right? So money beneficiary, this is the trustee. Now the monies are handled by the trustee, all right? So the children benefit from the money, but they don't have control of the money. So the trustee is the person who will manage, right, the monies. So when the trust is being set up, right, instructions can be given to the trustee to say, okay, here is, say, $5 million, right? Please manage it for this future generation, this beneficiaries, all right? Give them a monthly allowance, all right? If they need money for school fees, gladly pay. If they want to buy a car, all right, give them enough to just buy a simple Japanese or Korean sedan car, all right. If they enter the relationship and they want to get married, all right, give them so much for wedding expenses, right. If they have children, give them so much for the children. So in this way, the money never gets how the money is spent is never decided by the beneficiary, but rather based on the instructions given by the person who has set up the trust to the trustee. Okay, right. So this is how a trust works. Now, when we bring it back to a property purchase scenario, all right, there have been a lot of cases whereby the grandparent or the parent, all right, feels that there's so much money, all right, or rather, I do not just want to leave money, I want to leave behind something that would appreciate this time, or I want to buy a property and for the benefit of this child. So what happens is they set up a trust, all right, they don't put money in per se, but they set up a trust, a property trust for the purpose of purchasing a property, all right. So this property is bought, all right, for this future generation. It's under a trust arrangement. So again, the ultimate beneficiary of the property or the monies from the property will be the future generation. Yep. Okay. And how the property gets handled during the period of the trust, this future generation cannot decide. So this prevents this person from mortgaging the property away for money or selling it to cash in on the property without the trustee's knowledge or endorsement. Okay. How did using a trust to buy a property come about in the recent 5 to 6 years, especially? That's right. Now, what happened was in 2012 or if I'm not wrong, it's what 2012, 2013. There was a change to the additional buyer stamp duty. It went up by quite a bit, all right. And a lot of parents, right? So traditionally, a lot of parents that already have a property, all right, if they buy a second property as additional buyer stamp duty, but if they have kids, they are above 21 years old, they would then use their kid's name to buy the property. So using the kid's name to buy a property, there is actually no additional buyer stamp duty, right? But we also had a lot of parents who had kids who were below the age of 21. So the minimum age to enter into contract to purchase the property in Singapore is 21 years old, right? So if you're below 21 years old, you cannot enter the contract to purchase the property. So a lot of these parents, all right, then decided, or through the advice of the agents or the lawyers, then found out that, hey, actually, they can, through a trust instrument, still purchase the property for the benefit of this child that's below 21 years old. And this purchase will not be subject to additional buyer stamp duties. The reason it is not subject to additional buyer stamp duties is because for IRAS, when they do an assessment on how much stamp duties is to be paid for the purchase of the property, they actually look at the beneficiary of the property. So in this case, the beneficiary is a child that is below 21 years old, and therefore, this purchase will not be subject to additional buyer stamp duties, right? So a lot of buyers then decided, oh, I want to use a trust to purchase a property because my kid is below 21 years old. We want to buy it now, and we don't want to pay ABSD. Now, to answer Darren's initial question on trust, all right? How has this affected property transaction purchases, or if you are a parent, or if you are someone who is looking to purchase this property by way of setting up a trust for the benefit of this child, what are the things you need to understand and take note of? Now, number one, all right, since I started explaining about trust to now, all right, I guess most of you would understand that when a trust is being set up, all right, it is for the benefit of someone, all right? And when we say it's set up for the benefit of someone, it means that the person who set it up no longer owns the money. All right. So the first thing you need to understand when a trust is being set up is that whatever money that is being put into this trust, whatever money that's being put into this trust to purchase the property no longer belongs to you, the person who is coming out with the money. All right.
Right. I give you a quick example. I have two girls, right? Now I buy a property under trust to my eldest daughter, for example. So I become the trustee, and my eldest daughter is now the beneficiary. Am I right?
Correct.
Correct, right?
Correct. You're right.
So,
yes, correct.
But obviously at her young age, she has no money, right? So if I
Correct.
buy $1 million property, be it a resale or a new launch, basically the value is $1 million, and I pay 1 million Singapore dollars plus the normal stamp duties into this trust to my eldest daughter. Whose money is this? Whose money does this belong to?
Okay, to answer the question, whose money is this? The money belongs to who now, basically?
Yeah, correct.
It's your daughter's. It is your daughter's money. The moment you set up the trust arrangement, all right, to benefit your daughter, you do not own the money anymore, all right? The monies are your daughter's, all right? You are the trustee. You only exist to manage the monies, but they no longer belong to you.
All right. Okay. So I can manage the monies. Can you give an example? What do you mean by I can manage the monies? Meaning to say that if now I buy a resale property, a 1 million property, for example, it's under trust, right? So they are paying a rental of, let's say, $3,000 a month. So I'm collecting 36,000 a year. And I use this money and I bring the whole family to Europe trip. So the beneficiary is my daughter, ma?
Yeah, okay. Now, strictly speaking,
okay, right, guys, I'm just shouting out funny examples, okay, to keep this a bit entertaining. But the thing is that I do know for sure one thing is that a lot of trustees, let's use the correct term, a lot of trustees think that they can use that money for all these things. I'm telling you that you can't, and you better don't get caught, because this is supposed to be for your beneficiary. So now, Ted, add on a little bit. Okay.
So first of all, let me just explain to clarify. So as a trustee, all right, who is in charge of the trust, you have a fiduciary duty. So fiduciary duty means that you have a financial obligation, all right, to the beneficiary, all right. So the trustee, given this fiduciary duty, all right, has to ensure that whatever money that is received from either the sale of the property eventually or from the rental of the property, these monies have to be used only solely for the benefit of the beneficiary. So in the case that, in the example that Darren gave earlier, the monies can only be used, right, for his one daughter, right? So the $36,000 that is received annually can only go towards the expenses of his one daughter, right? It cannot be spent on Darren or his wife. So if the whole family goes on,
What about my other daughter?
No, can't.
Unless I buy that under beneficiary, which is two of their names.
Correct.
Then I can use that to pay. Unless both of them are the beneficiaries, lah.
Yes, correct. Unless both of them
okay.
are beneficiaries of the property, of that property that's being held in trust, then you can spend on them both.
Okay. So back to my question: what if I use the money?
Okay. So what if you had used the monies and
who is to know?
Okay. Maybe a lot of people will think that no one will know, all right? But I just want you to understand that if it comes to the day where someone knows, all right, then the beneficiaries can actually sue the trustee. All right. It is true. It has happened before. All right. I don't buy the say or the saying or what some people advise that in a family it's all fine. All right. All over the papers, Hong Kong dramas, we always see or drama serials, we always see families that get torn apart because of money, right? Be it whether it's siblings or parents and siblings. So there is actually no guarantee, all right, that your child, all right, will not sue you for the money if they come to know that it has been mismanaged.
Okay, thank you. Next thing moving on is that if I were to sell a property and held under trust, all right, what happens if I sell this property within the first 5 years? Can I do that?
Okay, now the thing to understand about why there is this saying that if a property is bought in a trust arrangement, it cannot be transacted within the 5 years. Now, it is not only if a property is bought under a trust arrangement, but if a property was bought or transferred as a gift from A to B, all right, say for example, all right, I own a property that is fully paid, all right, and I decide that I want to give the property to Darren. So I transfer the property to Darren as a gift. So when there is this gift transaction, which is going to be reflected in the title of the property, all right, from the day that Darren takes the property from me as a gift, right, in the next 5 years at least, right, he cannot transact the title to the property, meaning that he cannot mortgage the title to the bank to cash out for monies. Neither can he sell the property to someone else. All right. What this comes under is actually the Bankruptcy Act, right, in Singapore. So what happens in property transactions is this: if you are familiar with the resale option to purchase residential properties, there will always be this clause in the option to purchase that says that if there is a voluntary conveyance of the title to the property, and this voluntary conveyance, this transfer took place within the last 5 years, 5 years from today, right? So today it's, let's say for example, today is the 27th of April 2020. So 2015, 27 April 2015 onwards to today, if Darren had received the property as a gift from a person during this period of 5 years, he cannot transact the title to the property. All right. This has got to do with the Bankruptcy Act. So when a person is made bankrupt in Singapore, all right, the OA, the official assignee, which is the government department that is appointed to look after the bankrupt person's finances, will dig into the bankrupt's financial history over the last 5 years. All right. So what happens is a lot of people, before they become a bankrupt, whether voluntarily or before they get sued for bankruptcy, they would think of ways say that, okay, if when the person being made a bankrupt, at the point in time when he's made a bankrupt, anything in the last 5 years that he had given or transferred away, all right, they look upon it as an act, all right, of this person, all right, to hide away his assets so that it will not be called upon, all right, or to be used, all right, to pay, all right, the people, the parties that the bankrupt owes monies to, right? So the time frame is 5 years, which is why in property transaction, this gets brought in, right? It's actually part of the statute as well, where it states that if a property is transacted as an element of this gift, all right, then the title of the property cannot be transacted for 5 years. Now, a trust is basically a gift, right? Money is put in the trust for the benefit of beneficiary expenses, or money is put in the trust for the purchase of a property, are a gift to the beneficiary, right? So therefore, it gets caught in this. So there is no way a person who knows that or for a person, or rather, there's no way for a person to plan for bankruptcy and then say, oh, okay, I'm going to file for voluntary bankruptcy, or I know that I will be sued for bankruptcy in the next 1 to 2 years. Therefore, I know that I cannot transfer things for free, right, to my friends or relatives. Let me hide it in a trust, right? You can't as well, all right? So that's why we say that if the property is bought by way of trust, right, there can be no transactions for 5 years.
I see, because they can dig. If I'm bankrupt now, they can dig back my past 5 years and they can recall back all my assets. Are you saying that?
Yes, basically that is what I'm trying to explain.
They can claw back whatever I've actually gifted out for the past 5 years.
Yes,
right.
Correct.
But what I heard, again, you're saying?
Yeah, maybe you first.
Yeah, so I heard that if you were to sell within the first 5 years for a property bought under trust, not as a gift, property bought under trust, you can, but the buyer that bought over the property must pay in cash.
Okay, so this part comes in because...
so it's trust and gift different.
Okay, I would say that it's supposed to be the same, all right, and there should be no transaction within 5 years, all right. The part about whether the buyer has to pay cash or take a loan, all right, it has to be at least 5 years from the date of the purchase, right? For banks, right, to even consider giving a loan. What I'm saying, giving a loan is to the new buyer.
The new buyer, yes.
Yes, correct. No, the banks will not agree to actually grant a loan, all right, if it's still within the 5 year period.
But it's before 5 years? Are you saying that properties bought under trust can be sold?
Generally, no. That's not how we will advise.
Generally, no. So they wait for 5 years before they can sell. After 5 years, then they can do that.
Correct.
So it works the same as a gift, right? You say?
Yes, correct. The concept behind it is supposed to be the same.
So it's, for example, right now, I have 2 private properties already under my name, for example. All right. And my father decided to give me another private property. Can he do that?
Okay, if you have 2 private properties so Darren has 2 private properties in his name. And if his father decides to give him, so the father is alive and he has a property and he's giving it to Darren today. All right. Yes. Darren, to take in this third property, all right, this property will be his third property, will have to pay buyer's stamp duty plus also additional buyer's stamp duty based on third property. So it is going to be 15% additional buyer's stamp duty for Darren to receive this property as a gift from his father.
Okay, so the difference is that as a gift, they actually do count on the beneficiary's number of properties owned, but in terms of a will, then there is no stamp duty to be paid. Am I right?
Okay, so to just clarify this, so if a living person transfers the property as a gift to a living person, all right, stamp duty and additional buyer's stamp duty applies based on the profile of the person who
The
is
beneficiary lah.
receiving the property, correct?
Okay.
Now, but if a property, all right, is transferred, so the property is owned by a person that has passed away, and it is now being transferred to a living person, there is no stamp duties. There is no stamp duties at all, right? So there's no buyer stamp duties and there is no additional buyer stamp duties. Zero stamp duties apply, right? Because, all right, that it is transferred from the estate of a person who has passed away to a living person.
Okay. All right. Next thing is that what is the cost of the legal fees if you buy property under trust?
Okay, generally, the fees for trust is about $4,500 to $5,000 to set up.
Because you must set up a
document.
trust, is it?
We will do the document for the trust.
The trust is $4,500 to $5,000, right?
Correct.
Okay, right. All right, now I'd like to go into, actually we are about time already, but I want to squeeze this in because I actually left this to the end, guys, because this is something that is very prevalent right now. I'm in fact also being affected, right? So before the start of COVID-19, I was already in dialogue with Ted about my personal properties. And then I wanted to actually put this up to all of you because I think that some of you might be in the same situation or have even more properties than me, and you're now facing issues with the tenants, and then what are your rights as a landlord. And if you are also like me running a business and I am now both a tenant and a landlord, I want to know and be very sure what are my legal rights right now based on COVID-19, right? So first question that will come to mind is that as a landlord today operating, just a summary, so whatever that we're going into right now is fully commercial and industrial, guys, because the government did not state anything about residential properties. Okay, so my examples moving forward is all pertaining to the commercial and industrial properties in Singapore. Okay, so if today you're operating and you're a landlord of a commercial property, right, and the tenants are not paying you a single cent, what is the recourse of the owner?
Okay. I'm sure most of you or all of you here would have already know or read or heard in the news about the COVID-19 Temporary Measures Act 2020. So when COVID-19 started as Wuhan coronavirus, then it became COVID-19, right? When the situation got bad, right, the government actually came very quickly to form a task force, and thereafter, all right, they also very quickly, all right, came up with the COVID-19 Temporary Measures Act 2020, right? So one of the reliefs that was in this Temporary Measures Act 2020 was relief for commercial and industrial leases, all right? So like Darren explained earlier, it's only for commercial and industrial, does not cover residential properties, all right? So the relief that or the relief measures that were announced for this, number one, right? It all begins when the government became very concerned, all right, of the financial well-being of businesses. And when we talk about businesses, all right, they don't refer to the landlord, right? They are talking about businesses that are actually outside. So you're looking at your maybe your food shops, all right, your laundry shops, right, your supermarkets or whatever tenants, retail tenants that are out there, right, businesses. Now, it is expected that because of COVID-19, all right, and because of the circuit breaker, all right, retail outlets, right, would suffer losses, right, or would suffer lesser earnings. They won't be able to earn lesser. So the ability to pay rent and the ability to pay salary will be affected because their monthly takings will be affected. All right. So like most of you already know, all right, there is relief given for employers. The government has actually announced that for the month of April and May, they would pay to employers 75% of their employee salary, right, up to a salary cap of 4,600, of course, right, for them to relieve them of their salary commitments to the employees, all right, and also, all right, to help, the tenants, all right, they have come up with the relief for the commercial and industrial leases. So first of all right, Mr. Lawrence Wong, in one of the newspaper articles, he put it very simple, all right. So long a tenant, all right, during this period of time, all right, is unable to pay rent, all right, all he needs to do is to tell the landlord that I am unable to pay rent, I am seeking relief under the temporary measures. You don't even have to be that technical, just say I cannot pay rent, all right, I cannot pay rent, right? Okay. And the landlord, upon receiving this message, right, has to waive, not waive, use a more correct word, has to allow the tenant to defer the payment of rental. So to get it correct, it's not like it's not that the tenant doesn't need to pay forever, all right? What happens is the tenant can tell the landlord that, look, it's a very bad month to this month. It's going to be very bad months for me in the next few months. I'm telling you, under the Temporary Measures Act, that I, as a tenant, I can inform you that I will not be paying you rental. I will pay you this rental after, all right, this has ended. All right, so the period that we are looking at is actually from 20th April to 19th October 2020, that a tenant can tell the landlord that he is not going to pay rental and to look for the payment of rental, look towards the payment of rental only after 19th of October 2020. That's one, all right? Second thing, now, before we had circuit breaker or the COVID-19, all right, if you were a commercial landlord and you had tenants who didn't pay rental, all right, it would be a very common thing for you to actually get lawyers, right, to go and write a letter of demand, right, to send to the tenant to say, hey, you know, you are 7 or 14 days behind rent, right, and demand for rental to be paid, and it's still not paid, all right, for the landlord to get the lawyers, all right, to serve a writ of summons, all right, to claim the outstanding rental, and also get the lawyers, right, to go to court to get a writ of eviction, which is to evict the tenant from the premises. Now, under the Temporary Measures Act 2020 for this COVID-19, right, landlords are not allowed, all right, to, all right, sue the tenant for rental arrears, terminate the lease for non-payment of rent, right, exercise right of re-entry or forfeiture, or issue distress over assets in the property. So when we say issue distress over assets in the property, means that the tenant, the landlord cannot go and get a court order, right, to go and take the assets in the shop to sell for money to pay towards the landlord for the rent back payment. So all this are actually not allowed, all right? And this is only available for tenants who have not been able to pay rent. So they actually backdated it. It was announced in April, but they backdated it to 1st of February. And if the tenant has already today told you that he doesn't want to pay, cannot pay rent, all right, then you have, as a landlord, you have to accept it, right? So this, in short, is what has happened. Okay, so
you're saying, Ted, so you're saying that only for leases signed from 1st of February onwards is covered under this act?
No, I'm saying that if the tenant has failed to pay rent from, or is unable, or has faced difficulties from paying rent from 1st of February onwards. So actually, whatever that is before 1st of February, as a landlord, you can still sue for. But then you see, we got to understand a bit more about this 1st February timeline. Now, the temporary measures was actually announced before the circuit breaker, correct? I met you before the circuit breaker. So it was actually announced, the intention to announce these measures was actually end of March, all right?
Yes, it was in March, that's right.
Correct. Yeah. So COVID-19 itself actually made itself onto our shores late January, because Wuhan was locked down on the 23rd of January. All right, so that's where China locked down Wuhan, and we started to have cases of the Wuhan coronavirus late January Chinese New Year period towards the end of Chinese New Year. So what the government has done is they have allowed the date, right, they backdated the date of non-payment to 1st February onwards.
All right.
Right. So if you have the landlord and you had a tenant, all right, who from 1st February onwards was unable to pay you rent, they actually qualify under these temporary measures act to tell you that no, I will not pay you that rent for February and March and now April. Look for me
in
after
October, right?
October. Correct.
All right.
October.
So after October, they can then now go through the legal system to get the monies back. But I think they did actually also state that it could be 6 months to even a year, depends on the situation, right?
Yeah. Okay.
Yeah.
So if you look at how the relief was announced, all right, it did state that the end date could be 19 October or such time as may be extended or shortened by the government. So it depends. All right, it might get extended. It's like how our circuit breaker from an initial 1 month is now being extended for another 4 weeks. All right, so this period might be extended. So actually, the message that or what landlords should actually understand is this: it's not that your tenant does not need to pay you rent, meaning that it's not like the rent that was supposed to be paid has disappeared. All right. Rather, what the government is trying to, the message the government is trying to deliver to landlords through these temporary measures is that it's very tough for the tenant. All right, a lot of businesses, because of circuit breaker, like especially now, are not even allowed to run. All right, the rental that you're supposed to collect is still considered owed to you, but don't collect it now. All right, collect it after the period is over.
Understood.
Right.
Now, the rights of the landlord right now, if for example, rental is $1,000 a month, owed to them from February all the way to October, right? All right. So I'm okay to delay the rental payments and only collect when the time actually permits me to collect, and the tenant is also agreeable. Then am I able to charge my 10% on the non-payments in the past 6 months?
No, you can't. You cannot.
So only the agreed rental amount. I can't put in any penalties or fees that contractual itself permits me to.
No, you can't. You cannot.
Okay. All right. So at least you all know now cannot.
Yeah, you can't, because by law, all right, by law today, the tenant is allowed to inform the landlord that he is not able to pay rent, and therefore the landlord must give in to the tenant request to not pay rent. But okay, not that there is no recourse for the landlord. All right. When they announce this, release these measures, they also know, or they also catered for the recourse, what recourse a landlord can have, especially if, let's say, your tenant is not under distress financial, is not under financial distress, and is actually still operating or is actually able to pay rent. All right. So what happens is the landlord can apply through the Ministry of Law to get an assessor who will decide, all right, whether the tenant's request for this relief is fair to the landlord. All right. So there'll be an assessor who can come in, all right, to assess the situation, to see whether this tenant really is not able to pay, or the tenant is just taking advantage of this relief to not pay. All right. So what you can do is, I can send Darren the link later. Darren can send you guys the link. You can actually go to, let me see whether I can get a link now so Darren can send out. Darren, you have a group chat with them, correct?
Yes.
Okay, I'll send you guys the link. Okay.
All right.
Okay, so what I'll do now is I'll send this to Darren. Darren can send it to you guys. Okay, so I've given Darren the link, which Darren will now put it in the group chat. All right. Yes. So application for assessor's determination. So if you are a landlord and you find that your tenant is trying to take advantage of the situation, you can actually put in the application to Ministry of Law. Currently, there's no charges for it. I think it takes turnaround time about 2 to 3 days, right? They will get an assessor down. I don't know how it works. I've not had anyone who tried it, right? But based on my reading and understanding of it, right, there will be this neutral party appointed by Ministry of Law who will look at the request by the tenant for this relief to see whether the tenant really is in need of this relief, right, from the landlord. Right.
And then if let's say the reverse happens, so the tenant has informed the rights of the tenant has not informed the landlord that I am not in this situation, so I'm going to put off my payment to you to the next couple of months where I'm in a better shape, okay? Because I know for sure that besides the government-owned properties, they have totally waived 1 or 2 months of rental to the tenants, right? The law has, just correct me if I'm wrong, Ted. So the law says that you have to give back 1 month to the tenant because that is the waiver of the property tax. But now it has come to the 2nd month, and therefore some landlords, those personal owned ones, are not giving any relief to the tenants, and it is also their right, am I right, not to give any relief?
Okay, let me just answer this has a few parts to it. First of all, Darren actually spoke about tenants in government-owned or government-managed facilities, right? So what happens is if you are a tenant in a commercial tenant in a government-owned building or shop or whichever we call it, all right? Previously, they had half month rental free waiver, right? This has now been extended to 2 months, all right? Then for the other government-related agencies, like for example, if it's the HDB, URA, BCN Park or JTC or such, all right, I think they have half months worth of rental waiver as well. For guys like you who are private commercial owners and landlords, all right, what the government has given you guys is a rebate or waiver of your annual property tax, and it is now law that whatever rebate or waiver that you receive, all right, the exact amount you have to pass on to your tenant, right? That is your legal obligation at this point in time. Whatever savings or rebate or whatever they call it, right, that you have received on property tax, you have to give it to your tenant, right? Once you've done that, you have no other obligations to reduce rental or reduce rental. Okay, you have no other. Okay, you have no.
I'm working. Yeah, I'm working. Right, sorry, rudely interrupted by two girls. Okay.
Okay.
All
so
right.
You have no obligation to give any further discount or any further rebate or whatever you want to call it to your tenant. But if your tenant notifies you that they want to seek relief to not pay rent, then you have to give it to them for the period.
All right. So in this period of time, the landlord becomes unreasonable and does change a lock or lock up the premises. What can the tenant do? Is there a government body they can reach out for assistance, or they have to settle amicably with the landlord?
Okay, so this is very interesting. Now, earlier part of this session, we talked about locking up a residential property. All right.
Right.
Now we are talking about commercial property, especially during this period of the circuit breaker and where the enactment of the COVID-19 Temporary Measures Act 2020 is in place till 19 October 2020. So like I explained to you earlier, from now till at least 19 October 2020, no landlord, all right, can go and lock up a premises.
Okay.
Yeah.
All right. If they do?
So now the law is passed that you cannot, right?
Yeah.
You cannot sue the tenant for rental. Therefore, you cannot issue a letter of demand, issue a writ of summons. You also cannot issue a writ of eviction. You cannot lock up the premises. You cannot exercise your rights to enter the premises. All right. If any landlord decides or does any of what I just said earlier, all right, then it is against the law. So
immediately the recourse on the ground, yeah. So if on the ground, they can just easily call 999, the police will come down and settle the matter, right?
Correct.
Now it's a criminal issue already,
criminal,
right?
Correct.
Okay. It's no more a civil thing anymore. Okay. Yeah. That's good. So these guys, those of you that owns other properties, either industrial or commercial, I think two things that Ted has highlighted. Number one, if you deem that the present business of your tenant especially is actually thriving today and is not affected by the COVID-19, yet they want to take advantage of the present situation or to pay you, you can go up to, I just pasted inside in the group chat here, right, under this Facebook Live. Go check the assessor come down and then they will settle the issue for you. And if you're already in this situation, if you are renting, like I am renting a place, operate my business, right? What you could do is to write in or drop a message to the landlord, let them know that you indeed have difficulties paying, because some businesses, especially in the building that I'm working in fact, the building that I operate in and Ted with us neighbors, all right, I'm at People's Park Center, he's just opposite, he's at People's Park, Chinatown Point. Right, so basically, some of them are in the travel business, and their business is affected way earlier than any one of us, and their shops have been closed for the longest time. Okay, so for these businesses, right, they can have the choice for cash flow planning to delay all payments till October end. Am I right?
19 October.
19 October.
Yeah.
All right.
19 October. 9 more days. 19 October.
19 October. Okay. Okay. So right now, back to what I said. I just want to be very clear about it. If today I am with the travel agency, I am a worker, or I am even a flight attendant, okay, as a tenant, and now I am on a no pay leave for the next few months. All right. I am in a residential property. Is there no recourse for me, or is just up to me to speak to my landlord for sympathy?
Okay, so now the question is, if it's a residential property and you're a tenant in a residential property.
Both. So you're a tenant and you're a landlord.
No, there is nothing announced for residential tenancy.
All right.
So so same goes for a residential property purchase and sale. Right, a residential tenancy agreement terms and conditions continue to apply. Right.
All right. So
relief measures are announced for residential tenants.
So let's discuss in terms of the legal proceeding, right? So now tenant don't pays me. All right, again, the same thing, they cannot go down and lock up, okay? I don't know why I keep using the word lock up, because I think this is what a lot of people will do. You cannot access, you lock up the place, right? Okay, so anyway, what is a correct legal proceeding in Singapore for a landlord to either demand for payment or to evict out a tenant in a residential property?
Okay, I guess most of you have heard me use the term letter of demand, writ of summons, writ of eviction quite a lot in the last half an hour. Because we've been talking about rental. So the proper process by right is, if there is a tenant who is owing money, the landlord has to engage lawyers to serve what we call a letter of demand. So a letter of demand is a letter by the law firm written to the tenant to inform the tenant that rent has not been paid, and the landlord is officially demanding for the payment. So that's called a letter of demand. So in the letter of demand itself.
So hang on, Ted. When can they ask the lawyers to issue the letter of demand? At which
the
point
moment the moment the rental is not paid, you can. So for example, if your rent is due on the 1st of the month, all right, you can on the 2nd of the month, ask the lawyers to write the letter to say that the rental is not paid. Though in practice, no landlord or most landlords will not do it, because it will cost about $200 to $300 for this letter of demand. right? So usually the landlords will wait for that few days. Sometimes it's not unusual for tenants to be late.
A bit
right,
late.
due to
All
some
right.
reasons. Yeah, correct. So, but technically you can, the moment it's due, you can get the lawyers to write the letter of demand. So you need to write a letter of demand first, right? And in the letter of demand, usually we'll give them a period of time, say 7 days to make the payment. If they fail to make the payment, then the landlord now qualifies, right, to issue a writ of summons. So a writ of summons is where it once issued, all right, on the party, all right, in this case, the tenant that is owing the money, all right, the tenant has to either settle it, or if it's not settled, then it will go to court, all right. So when it goes to court, all right, then the court will actually look at the case, and if they find that the landlord is correct to issue a writ of summons, they will give a judgment in favor of the landlord. So what happens is the judgment will be passed to state that the landlord is owed this money by the tenant, and what the landlord can further do is to exercise that judgment. So maybe to get money from his accounts or whatever. But I just need to qualify first. Right? The amount needs to be great enough. All right, it needs to be at least $10,000 or $15,000 for it to be worth the while for the landlord. All right, why? By the time you get lawyers, all right, to issue the writ of a letter of demand and the writ of summons and go to court to get a default judgment, it's going to cost you like about $4,000, right? And if the amount owing is less than $10,000, actually you have the small claims tribunal, right, that you can turn to, right, where lawyers are not allowed to represent any party, all right. If the landlord intends to make the tenant a bankrupt because of this rental that's owing, it needs to be at least $15,000 at least, right? You can't be making a person bankrupt over $2,000 or $3,000, which is in most cases 1 or 2 months rental. Right. Okay. So I can give you the process, but realistically, all right, no landlord will go down this route unless the money has been owing for a very long period of time, and or the monthly rental amount is huge enough to justify such legal action.
All right. So basically, the legal action that you have just shared with all of us is to get the correct documents to evict the tenants, right?
No, I've not talked about the eviction yet. So this is only to get to the stage whereby it is confirmed by a court that the tenant owes you this money. All right. So if you want to do the writ of eviction, all right, it is an added process. You need to go to court, all right, to get an order to evict the tenant. Right now, when you get this order to evict the tenant, it basically simply just means that you have a court-issued document that states in very clear terms that the person that is living in this property should be evicted.
Okay.
Right. If you get such a document, then if you call the police will entertain you.
Okay. Okay. So normally from the day you give the letter of demand, all right, the writ of summons, all the way to the eviction letter, how long is that time you're looking at?
4 to 5 months, maybe.
About 4 to 5 months,
4 to
right?
5 months.
And again, all these legal costs is out from the landlord's own pocket, right?
Correct.
So now, after they get the eviction letter, does it also comes with claims, or is just an eviction letter?
If once you get the eviction letter, okay, when you say claims, meaning that is there any compensation to the landlord, is it?
Yeah, so I have meaning to say that because if I can get all these documents, the tenant will not be around, right? In court, or will they be around?
I can't answer for the tenant whether the tenant will be in court, but if you're looking at a case where the tenant feels it's a wrongful eviction, then definitely the tenant will be turning up in court to defend this eviction writ. But if you are looking at a tenant who is really owing money to the landlord, I don't see why or how this tenant can turn up in court and to tell the court that he should not be evicted. So chances are, if it's because of rental owed, the tenant will not be turning up in court to actually defend himself.
So then the judge would then pass down the eviction letter, and would they also pass on to say how much owed have to be repaid back to the landlord?
Yep, of course, at the point in time, everything will be taken care of, all right? The total amount of rental owed, all right, plus whatever late payment penalty that you can actually collect, plus also the order to actually so-called to actually evict the tenant, right, will all be taken care of. So the lawyers representing the landlord will ensure that all of these are obtained for the landlord.
I see. So after that, would the lawyers be the one that go down to evict, or the landlord would be the going down to evict the tenants? And when the landlord comes down, what's your advice? Should they bring on someone else to do any video recording, or how should the correct process be?
Okay, generally, all right, once you get the eviction order, all right, the landlord can actually go down to the property to rightfully and lawfully evict the tenant, all right. In most cases, to what I understand, in most cases, if the tenant is a reasonable person, when they obtain such documents, they will have vacated the place, right? In cases where the tenant refuses to actually vacate, then you can actually get the services of, or not services, you can buy their services. You can actually call the police to come down to help you to enforce the order, because it's actually a court order that can be enforced.
All right. And what should the landlord do if in the event the tenant still doesn't pay? Would it then be a civil case?
Yes. Okay. So just to be clear as well, all right. You have actually a case whereby monies are being owed by a person to another person. All right. So how I always explain it is this. All right. There are people that owe the bank monies. There are people that owe Singtel, StarHub, and One Monies. There are people that owe banks, UOB, DPS, OCBC monies. All these are civil cases. All right. So owing money is not criminal. All right. And even the banks or Singtel, StarHub also have to write off bad debts after a period of time. So if you happen to be a landlord where your tenant has owed you money, even if you get a court order or a judgment in your favor, whatever, it doesn't mean that you automatically monies from the tenant's bank account be credited to your account, right? Even a bank, Singtel, StarHub, and One does not have such they don't get such arrangements, right, where you owe the bank money and automatically your savings account gets deducted to pay them. The only party in Singapore where if you owe money to and you don't pay, they can automatically deduct from your bank, or they can order appoint people to collect monies from you is IRAS. Correct. So when a person owes money to IRAS can take the money from the bank account. But in all other cases, all right, be it whether you're a landlord or the banks or Singtel, whatever, if monies are owed to these people, right, and the tenant who refuses to pay, then there is nothing further that the landlord or Singtel, the banks can do, right?
Yeah, unless they want to sue them personally.
Yeah, unless it gets to the point, to the stage of bankruptcy. But like I explained to you earlier, bankruptcy requires a minimum amount as well. You can't just bankrupt someone over $1,000 or $2,000.
15,000, right? You're saying?
15,000.
I see. Okay, so another question came in. It's a small one, but I think they want to know the correct procedure. For the tenants, right? For example, a water heater is faulty at home. they call the landlord to do, the landlord don't want to do, you know, then they hang on for a week, the tenant get fed up, they just replace it on their own and deducts automatically from the rental payable. Is this the right way?
Okay. First of all, I want to say this. Is there a law on this? No. All right. So a lot of times it is based on the terms and conditions in the tenancy agreement. Now, the template tenancy agreement that is being used, template tenancy, residential tenancy agreement that is being used, all right, it always says that the landlord is responsible for minor repairs up to a certain amount. But there's no law to say what this amount is. It can be $50, it can be $100, $150 or $200 or $1,000 per item. All right. Now, the thing is, a lot of landlords or residential landlords in Singapore, they operate on the belief that their properties do not degenerate over time. Right. That is actually the issue. A lot of landlords in operate on the belief that their property does not degenerate. So when I say does not degenerate, I mean the day that they buy the property and prep it for the first tenant, right? Even after they have rented it out for 10 years, right? They expect nothing in it to spoil, right? Which is actually very difficult to understand why they have such a belief, all right? And this clause in the tenancy agreement is actually fair to both the tenant and the landlord, if you look at it from a practical point of view, all right? A tenancy usually runs 1, 2, or 3 years, all right? And appliances, all right, or products or items in the property, right, could malfunction within this 1, 2, or 3 years, all right? Why there is a minor repair clause, all right? It being fair to the tenant and the landlord is this. Now, the landlord owns the property and the items in the premises. At the end of the tenancy, the landlord will take all of this back, and if all of these are in working condition, the landlord will reuse it to rent it out to the next tenant, or the landlord can reuse it for his own benefit. All right. The tenant, on the other hand, all right, is holding on to the property and all these items during the period of the tenancy and is enjoying it, all right? And he is therefore wearing out the items. Okay, so right. we agree from these 2 points. So a lot when you have this minor repair clause in the tenancy agreement is to make both parties committed towards the item. Right, because both parties ultimately do benefit a bit, but of course at different times on the item itself. Right. So in your case, let's say it's a water heater. All right. Water heater to spoil. All right. And if it spoils, all right, then you have the tenant first paying the minor repair costs. All right, and then the rest of it to be borne by the landlord. That's the usual, isn't it? All right. So your question was, what if the landlord doesn't want to come by to repair it, all right? And then the tenant, because it's water heater or aircon, you cannot tahan for too many days or so, all right? Decides to go and get it repaired, all right? And then decides to let it off the rental. Okay, there are a few things here. Because the tenancy agreement states that both tenancy agreements actually very briefly or maybe clearly states that if an item needs to, if an item breaks down, all right, the tenant will need to notify the landlord, and the landlord must they use usually the word a reasonable period of time, right, come by to have it repaired. It doesn't state the number of days, all right? So if you are a tenant, what I would suggest is to make it clear, instead of using reasonable period of time, to actually state an X number of days. Say the landlord must respond within 1 day or 2 days. All right. And as a landlord, the landlord can know that he only has 1 or 2 days to come by to take a look at this item. All right. And because the tenant bears only the minor repair cost, whereas the landlord has to bear rest of the cost after the above the minor repair cost, the tenant must also allow the landlord time to come by, take a look, get a service technician down to assess whether it can be repaired, how much it will cost, and or if it's to be replaced, whether the items can be found. All right, so or what item is it to be replaced, and this has to happen within 2, 3, or 4 days if you stay in the period of time that the TA, right? When the landlord has to come by to have it done. All right. If the tenant without the consent of the landlord then goes and replace it and deducts it from the rental, is actually not correct. All right. Because the question would be, could the item have been repaired, right, at a much cheaper rate, or could there have been a cheaper way of replacing the item, which now the tenant has, without the consent of the landlord, decided to go and commit to this amount and then throw it on the landlord. So that's unfair as well.
I see. So I think what you're saying is that how do we draft out your tenancy agreement clearly, right? If let's say you state that if the landlord has no MIA for a few days, then the tenant has the right to take matters in their own hand and get it replaced. Then that will be very clear, isn't it?
Correct. So if you exactly. So if you look at tenancy agreements, right, if to make it less ambiguous, if the parameters are set more clearly, then definitely if the landlord has failed to respond within 3 days, for example, all right, then it will not be unreasonable for the tenant to act his own, decision to replace or repair with whatever things that he can.
Good stuff. Okay, guys, we've all run already. I think I'm just going to have one more last question. Ted, is that all right? Last question.
Yes.
Last question is that is it possible to then, based on all our eviction we're talking about, there's a message that came in and then states that can they put in a tenancy agreement if there has been no payment of rental for the past 30 days or 15 days for the matter in a TA, the landlord reserves the right of re-entry of the property and to evict out the tenant. Does that make sense in the TA?
Let me just understand the question correctly. So you're saying that in the you are saying that to put in the TA, to include a clause in the TA to state that if rental has not been paid for 15 days, the landlord has the right to re-entry to the premises.
Yes.
I think most TAs, if not all, already have this clause in it which states that if rental is not paid for 7 days, all right, the landlord has the right to re-enter the premises, right? But let me just clarify or make better on this explanation. Now, for people who have taken a housing loan before, all right, in the bank's contract and in the security documents that you sign at the lawyer's office, all right. In short, I'll call it the contract terms already also states that in the event no monthly installment is paid or monthly installment is not paid on time or is owed for a long period of time, right? The bank has the right to re-enter. All right. Now, similarly, in a tenancy agreement where it states that there is the right to re-enter, right, it simply only qualifies that in the event of a non-payment of the rental, the landlord has the right to re-enter. All right. Now, versus if it is not stated in a tenancy agreement that, so for example, if it's not stated, if it's not provided in the tenancy agreement that the landlord can re-enter, so you will have a situation whereby the landlord is owed money, but he has no recourse. Whereas in the example given, the recourse is the landlord can re-enter. Okay. Now, having this clause in to say that he can re-enter does not mean that the landlord can simply barge in. Right. Same goes for the bank when they have this clause to say that they can actually take back the property, right, and sell it. they don't just walk in one day, take back and sell it. They go to the court to apply for an eviction or an order as well, right? As mortgagee, right? To to take in the property, all right? So they are backed by this court order, right? Same goes, I explained to you guys earlier, all right? For a landlord, right? You can go to court to get an eviction order. So basically, having it stated in the tenancy agreement only merely clearly states that if rent is not paid, this is the penalty, this is the consequence. But in order for the landlord to enforce this consequence, the landlord must still go and get a court order and not simply just say that I can just walk in because this is in the TA. What's in the TA only states what the consequence is, but the right way of doing it is actually to go and get a court order.
Okay, so are you then saying that based on your experience, there is no way we can draft a contract of a TA whereby the landlord is able to go inside the house, throw all the belongings out of the house? Worst case scenario. It all has to go through the proper Singapore courts, is it? Or can we already pre-draft it in the TA?
Okay, so the TA is, okay, let me just put this in very simple terms. All right. Today, Darren has a property to rent, and he's going to be the landlord. I'm going to be a tenant. Right. Our agreement to the rental can be very simple. No tenancy agreement. All right.
All right.
So I will take the property from Darren, and I agree to pay him, say, $5,000 a month. Right. But there is no terms and conditions. All right. So there is nothing to state, all right, when I must pay rent, or maybe we can agree that we pay rent on the first of every month, all right, and we agree to rent for 2 years, all right. But there is no other boundaries regard our relationship, right? We have no tenancy agreement to state if I don't pay rental, what's going to happen. If I don't pay rental after 7 days, all right, whether he can charge me the penalties, all right. What is his obligations to me as a landlord? What are my obligations to him as a tenant? We have none of these rules, right? We call it rules, all right? So if we understand this correctly, the tenancy agreement, the existence of the tenancy agreement is basically to set in place the rules that the rules between the landlord and the tenant.
All right.
All right. So of course, if it can be drafted better and it is drafted better, then it would better coordinate, right, the relationship between the landlord and the tenant. So that explains your query.
Okay, I get it. So basically, is you have to draft a better TA, but then again, ultimately, I don't think you are still able to just kick your tenant out. If I gather what you say correctly.
No, you can't.
You guys still have to go through the proper call. Anyway, just to give you guys, to rest assured you guys, because a lot of you are thinking about portfolio management, to buy a second property and to rent out. Okay, I have not had such a complicated case out of my many hundreds of cases. All right, so this is worst case scenarios, things that you read in the papers, whereby people can hold off a sale of a property in Bedok for the past 5 years. Okay, this was a classic case, but that doesn't mean that so many cases are like that. It's just the minority anyway. So, okay, I'd like to thank Ted for your time. It's been 2 hours plus already. I hope you guys find it fulfilling and has got a lot of content and a lot of benefits from this program, all right? Ted, can you just shout out your handphone number for all of you to contact him?
Okay, so, okay, take out my mobile number. It's 9168 8811. So it's 9168, then 8811. Right, my name is Ted, so it's spelled T-E-D. My surname is Koh, K-O-H, and I'm from Crossborders LLC. So just take down my number, take down my name. All right, you can save me to your address book. If you have any property-related queries, right, be it whether it's buying, selling a property, or decoupling, or like tenancy that we'll be going through, you can always WhatsApp me, and then I will reply you when I'm able to. Just let me know that you are from Darren's group, all right, so that I know where you got my numbers from.
Yeah. So anyway, I'm going to add Ted into our group also, so you can easily, if you can't recall his number, at any time, come and take a look at the number of members over here. Look for Ted Koh, and you can WhatsApp message him directly, and he's able to respond directly too. Okay, and with that, I wish you all a good night, stay healthy, and Ted, catch up with you soon. Okay, good night, guys.
Okay.
If you like the video that you have just watched, and it has given you better clarity in your property journey in Singapore, do help me out by hitting the like button and subscribing to the channel.